If I catch a witness in a lie at a deposition or at trial, do I make a big deal about it at that time, or do I wait? You want to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury lawyer practicing law here in the state of New York. The answer is there are a couple of different ways to address this. There are different tactics and strategies that we can use to maximize the effect of a witness lying either during pretrial testimony, in a deposition, or at the time of trial. So let me give you an example of what can happen at trial. Let's say I get a witness to make a statement that clearly contradicts something he said before. And it's obvious to me that there's a clear lie here. And now I bring out to the jury that there are inconsistencies in his testimony. Maybe he said one thing at the time of his pretrial testimony, and now he's saying something totally different. Do I simply go after him and spend the next 15-20 minutes pounding into him and getting the jury to realize that this guy lied, outright lied? Or do I wait? One strategy is to do absolutely nothing while you're questioning the witness. And why is that? Well, if you continue to hound a witness about an inconsistency or something they lied about, what will happen is now you're giving them an opportunity to correct something that happened in the past. You're giving them an opportunity to explain to the jury why they said what they did and why it's inconsistent with what they've said now. That's not the ideal scenario, and you certainly don't want to give the witness the opportunity to now rehabilitate something that he said before that contradicts something he said now. So instead, what the better practice is to wait until the time that we make closing arguments. During closing arguments, I can now turn to the jury and say, ladies and gentlemen, let me show you what Mr. Jones said. 2 years ago when he gave his pretrial testimony, look at what he said here. And when he was in court standing before you, he swore to tell the truth. And look at what he said now, 2 years later. Who do you believe? And now I can make a really big deal, and Mr. Jones is not going to be there to now rebut anything like that. And now it'll be up to his attorney, the defense attorney, to try and craft an argument to show that this inconsistency, that this lie, is not as significant as I'm making it out to be. So that's one of the key ways, one of the key strategies that we can use a lie during the course of trial in order to highlight to the jury that this witness is not to be trusted and their credibility is totally shot. So why do I share this quick little tidbit of information with you? I share it with you to give you an insight and an understanding into what goes on in the trial process here in the state of New York. You know, I realize you're watching this because you likely have questions or concerns about your own particular matter. Well, if your matter happened here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. This is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.